Hi there. Welcome to Module 4, Module D rather, of Poli-Sci 150 this semester at Sacramento State. And I'm your instructor, Daniel Kirsch, as you know. And today what we're going to do is I'll suggest that you watch this video first. This is the first video of three, I'm hoping, short videos for Module D. And the first video, we're going to be talking about federalism and states' rights. And California will be in a separate video, but California is, of course, the state we all currently at least are studying or teaching or learning about. And certainly it's the home of the California State University system. But this video is going to be more broadly about the kind of relationship between the U.S. federal government and the states. The California video will be second, and the third video will be about civil liberties specifically. And before I do that, before I launch into that, I'd like to just kind of situate us again where we are. You've probably just completed the midterm essay. I'm sure that was exhausting. I'm going to do my best to have that stuff back to you in next, if not by this next class, then the class after that, so that you'll at least have your grades before the next module is due. So, and this last week was inquisitive. So this week, you're going to be starting these next 2 weeks of Module D from October 26th until November 6th. You are going to be learning first this week about federalism and California state government and politics. And the second week, I suggest, watching the video about civil liberties and doing all of that work. And so doing the accompanying inquisitive for each one of those chapters is also part of the course. And so I urge you to do that. And then finally, of course, when you've kind of run through all of this material, that's when I'd like you to really go into the third part of this, which is the module exam. And there are this time 33 questions, multiple choice on the module exam, and about 2/3 of them are from the textbook directly. And I'm going to try to cover as much of them as I can, but as much as I think is probably reasonable. And the rest, you'll already have encountered it, hopefully, in the inquisitive or just by reading the textbook. And it's all, searchable in the index, of course, especially if you have the ebook. Should be easy with a little Control F action. This module is kind of strange, I guess, the way it's grouped together. It's the politics of aware of politics in the United States, because it's a little forced, obviously, with who, what, when, where, why, and how. But I thought it's kind of a fun grouping, and where I think makes sense because where we are is California, and California is one of the states. And because the states kind of comprise the national government, at least initially, and they continue to exist and kind of work in cooperation with the federal government, then I think it's appropriate that we say, okay, well, yes, where we are is in the states, and we're going to learn about the state relationship. But then civil liberties also is a tricky one as why to include this. And the reason I decided to is because there's a really important part of civil liberties that begin with the relationship of the U.S. Federal government to the states. So it does make sense. So hopefully it'll make more sense after you watch all three of these videos in terms of why they fit together so well. And then we'll move on to the next module when we're done with this. So to begin with, the politics of federalism, I want to just really go through these 10 points. Okay, and by going through these 10 points, as I'm sure you know already from watching my other videos, is I tend to just expand on each of these points and kind of see where the discussion might lead. And so I think just to begin at the beginning, as in a sense, the states were sovereign. What does sovereignty mean? Well, sovereignty we kind of went over in the first chapter, and they talk about it in your textbook in the first chapter. Sovereignty is kind of the power of self-determination. And when we're talking about states, we're talking about governments, really. We're talking about the kind of national or community right to self-determination or autonomy. It's the sovereign is the person or entity that has, as Max Weber, the German sociologist, famously said, it's the organization with the sole monopoly on the legitimate use of force against its own people. And so that's what the state is, and that's what the sovereign really is. It's the kind of principle of national self-determination. And, it goes back further than that, of course. It goes back to, at the very least, it goes back into Europe during the Renaissance period and after that. And of course, sovereignty was talked about in some sense in the classical era as well. But it began to be kind of obtain its modern sense when we started to talk about states in Europe with their sovereign right of self-determination of how much to allow Protestants and Catholics to live side by side or to persecute one or the other. And so sovereignty is really the recognized authority by other states, by other national sovereign governments to the right to self-determination within their own borders. And this is, I've taught international relations before, and this is really interesting when you start to talk about the United Nations and whether or not sovereignty is something that enhances or totally blocks human rights. And sovereignty, of course, is the principle that allows the United Nations to exist. So for the United States and Slovenia to have the same kind of legal basis, the same legal kind of rights as governments, even though the U.S. has massively more people and massively more money than Slovenia does, and not to mention military. But they're both states, and they both recognize each other's sovereignty within their own borders. So, and Russia, of course, and China, and all the rest around the world are all sovereign states. So, now that you understand the context of how significant sovereignty is to kind of modern governments, you see maybe why the word having sovereign power in the states was so important to the American states, to the North Carolinas of the world, and New York and Virginia, and that they were sovereign and they were self-determinate in a way that they weren't before they declared their independence from Great Britain. Collectively, though, as United States. And so that sovereign power really was a terrible, it was really carried out pretty terribly between when the U.S. declared its independence and when the Constitution was established. And the Declaration of Independence, of course, well, the war began in 1774, and then the new Constitution wasn't actually written until 87 and ratified in 88, implemented in 89. So about 15 years there, the U.S. had a pretty terrible form of government, the Articles of Confederation. And let me kind of come back to the difference between these, and I'll come back to what police powers are in a minute. But sovereign powers, they were saying that they were sovereign over their territories, and they were over their citizens, and certainly over their money and their taxes, of course. So they treated each other like the United Nations. The delegate from Georgia, the delegate from New Hampshire. All of these were different sovereign states, and they all had essentially one vote. And we've talked about that before, about how the Articles of Confederation work and why it was dysfunctional. And if you really want a refresher, I would urge you to go back and read and watch that Empire of Reason video. I'm a big fan of it, in terms of how it worked operationally. But it was called at various points a confederation. It was the U.S. in writing the Articles of Confederation that were adopted, I think, formally in 1781. But before that, operationally, they'd been working under this confederation for a while. Is that the language, I think, is important here. That federalism wasn't really a thing. The word federal just meant a federation, like an alliance of states. And a confederation is just an alliance of states, and so they were used interchangeably. A federation may be seen as stronger, but a confederation is more a looser alliance, I suppose. And so they use the word, instead of the United States, they would interchangeably use the word United States and confederation in the United States. The Articles of Confederation, what was the kind of original founding document. And so this sort of makes sense then, and if you read it kind of forwards through history, why the southern states that seceded, leading to the Civil War in the 1860s, several decades later, they called themselves the Confederacy, or the Confederate States of America. They claimed that they were being truer to the original spirit of the American Revolution, and of course the kind of founding documents and even the Constitution itself, whereas they were, in many respects, I mean, they were right, simply because they were they were saying that the original U.S. certainly did recognize and encourage slavery, and it certainly did only recognize a loose alliance of states rather than a more centralized authority and unitary government. And a unitary government just means the opposite of confederation. A unitary government is one that is pretty much centrally controlled, and one that doesn't really have a lot of subnational units. So by contrast to the U.S. today, even, and certainly the U.S. back then, you have a country like France or Great Britain, and both of them really have centralized authority in their capitals in London and Paris. And it was only in the 1990s that the UK, the United Kingdom, Great Britain, and Northern Ireland actually devolved some kind of what we would see as state powers or local powers to assemblies in Scotland, Wales, and Northern Ireland. And so they are treated today a lot more like the way that we treat states here. But that didn't exist until 1997, and so that was big. That was a really big change for them. Up until then, it had been very centralized. Oh, and I'm sorry, and the city of London as well didn't really have a mayor as such, and the mayoralty is in the council form of government. Even that before the 1990s was run centrally by Parliament. So it's a fairly unique system that the U.S. has, that it has such a unified kind of strong central government and strong state system. Hate to use them both as strong, but I mean, I can't think of another place that has both a such a kind of wide reach, as well as a really ingrained state political culture. I mean, maybe a couple of the other federal governments around the world, like India and Germany, might be a little bit similar. Okay, so that's a fair comparison. But today, the states, of course, aren't sovereign. So no matter what the language says, in their constitutions or in the federal constitution, today it's been a long-held principle of American constitutional government that the U.S. the U.S. states have police powers. And what are police powers? This is really before the modern term police really came into effect in any meaningful way. And there was some metropolitan police forces that had developed in the late 19th century. But until then, the word police was meant as just almost like a verb, they have police powers to monitor powers, to monitor and safeguard the health, safety, and morals of their citizens or residents. And so that kind of has translated today into a meaning that takes it to mean that, for example, police are almost entirely at the local level. There are, of course, now a significant number of state police, but traditionally police have been constituted at the local level. So that's one kind of police powers, police forces. But another is education, and education is extremely decentralized in the U.S. And so education is looking after the safety and morals, educating, giving a civic education, kind of citizen-oriented education to every citizen across the country is supposed to be available through public education. That's what the police powers have encouraged, and that understanding of police powers has encouraged up until now. And then certainly besides police powers, besides policing and education, there's healthcare, the health, safety, and morals. The healthcare has existed at the state level in terms of not only providing but healthcare insurance and healthcare itself, but also kind of monitoring the public health of the U.S. has mostly been a state function up until very recently with maybe the pandemic. But historically, the health, safety, and morals of all the states are police powers. The morals haven't necessarily carried over into modern language, so they more talk about health and safety police powers these days. But it was, at least in the 19th and early 20th century, that was the trifecta of health, safety, and morals. So that's what the police powers are of the states these days. They're not sovereign. They're just sort of, it's kind of a division of power and kind of a cooperative power now, because none of those areas that I mentioned are exclusive. And really no issue area is now exclusive. It used to be that they were very segregated in terms of their issue areas, and education was something the federal government wouldn't even touch, and as well as health and safety. But today, education is really cooperative between the federal government and the states, largely still funded by the states and the localities. But really, you're talking about a cooperative relationship in from everything from transportation to veterans affairs to labor to commerce. There are state and federal and local laws in just about everything. But I think to understand the way that they work, it's really important to understand how they originally were set up, and why there is such a division, and maybe what is supposed to be, at least in the traditional kind of constitutional framework and the idealized one, how government is supposed to function in each of these issue areas. And I think it's largely in terms of the character of which government is actually supposed to be leading the way on all of these issues. An early instance of something that's a principle called coercive federalism is an early 1970 instance of President Nixon famously demanding in a legislative deal with Congress, that they lower the legal blood alcohol content of driving on federal highways to, I believe it was 0.10 at that point. And later on, it was 0.08. But if your blood alcohol content was above 0.10, then you're supposed to be considered impaired or drunk while driving. And the reason I'm mentioning this is because he said that if you don't, to all the states, all the representatives of all the states in Congress, go back to your states, and if your states don't agree to lower this, I won't sign off on federal highway funding for you. And so that's very much an imposition of federal law to a state kind of criminal statute. And they had to go and pass individual laws in all 50 states in order to receive their state's allotted federal highway funding. And that was the deal that was made. And Congress did that again in the 1990s. They lowered it from 0.10 to 0.08 blood alcohol content. And also besides that, I'm sorry, your book may be talking more about the other restriction, which was raising the drinking age to 21 from where it was, which is either 18 or 19 in most states. So he was heavily lobbied by Mothers Against Drunk Driving and principally, I think, but others as well, religious leaders, I believe. But overall, it was just this really textbook kind of precedent of an extra legal political decision that was made, and it was imposed really on the states in a way that was not really legal, but was still politically agreed to because federal highway funding had become so central to the idea that members of Congress are supposed to bring home the bacon. They're supposed to bring home what they promise their constituents they're going to bring back, which is federal dollars in the form of roads, very often that need to be repaired. Another kind of federalism that you should be familiar with is competitive federalism, and it's in other places called the race to the bottom around the world. But what one instance of competitive federalism recently was about a year and a half ago, I believe. Amazon was trying to locate a factory or a large hub of its business somewhere else besides Seattle, where it's based, and they were basically going to every state and saying, how competitive of a package can you give us to be able to locate here? And they eventually settled on, I think it was DC, but it was sort of openly asking people to give them special treatment. And states were competing with each other directly and openly in public and in private with Amazon, saying that we'll give you all kinds of breaks on taxes, like you won't have to pay taxes here, and we'll give you, X amount of money, and we'll plan for your infrastructure, we'll help you in all these different ways. But they did a very simple cost-benefit analysis, and they ended up just, I think in the end, they said they wanted to come to New York, and then New York said they didn't want them, and because they wanted all kinds of tax and labor breaks as well, and through lobbying by a lot of politicians, they kind of scrapped the deal, but they ended up saying they needed to come to New York anyway because they needed an East Coast base. But competitive federalism is just the idea that different states give more money or to corporations, basically, in hopes that they will compete for the jobs that those corporations will bring, and hopefully the additional revenue that will, the tax revenue that will hopefully make up for the amount of money that they've lost initially from this deal. So, for example, like other businesses would do better, so they would get increased tax revenue from those businesses to make up for the loss of money from Amazon. So, competitive federalism is just states competing against each other economically, especially for jobs. The Commerce Clause is a feature of U.S. federal law that is really unique to the United States. in Article 1, Section 10 of the Constitution, um, there's, as I've explained before, there's something called the elastic clause that, any powers that are listed here, Congress has the ability to write more laws that expand the power of the federal government to carry out the powers that are listed here. And one of those powers that are listed is the Commerce Clause power. And that is very simply the ability of Congress to regulate not only interstate commerce, not only intrastate commerce. Let me go back. Not only interstate commerce, which is between states, but also intrastate commerce, which is within a state. And that Commerce Clause was kind of put to the test very early in the U.S., or relatively early, maybe 20 or 30 years into its existence, in a case called Gibbons versus Ogden, and it was about waterway rights in New York State, in lakes and rivers in New York State, and whether whether the U.S. government itself could impose regulations that were entirely within the state of New York, and the rivers that were entirely within the borders of the state of New York. But it really allowed for the Commerce Clause to be a powerful tool for Congress to use to refer to, who gave you the authority? What citizen talking to Congress saying, who gave you the authority to do this, to write this law? And usually the answer is the Commerce Clause, because they fall back on it. And at one point, that was how Obamacare was being talked about. It was going to be the reason why you could have a new kind of regulation with all this kind of healthcare industry regulation it was going to be imposing, is because it's in the Commerce Clause that the Congress can do that. That ended up not holding up in the Supreme Court, but that has more to do with the politics of the Supreme Court than anything else. And the Civil Rights Act, for example, was written as a function of the U.S.'s Commerce Clause, simply because the Civil Rights Act, among the things that it did besides withholding federal funding to entities that discriminated, it also forced businesses that were open to the public, and that were engaging in interstate and intrastate commerce, that were open to the public. They could not discriminate on the basis of race, and if they did, they'd be in violation criminally of the Civil Rights Act. And so this is where the controversy really was, and this is why people like Senator Barry Goldwater of Arizona, and all the southern states that had all this kind of political culture and legal culture built around the segregation laws that were passed after the Civil War, they really saw it as an overreach of the federal government, and I think it's fair to say that they saw it that way mostly because they had this culture of segregation, but also they really did believe, many of them, that this was, or at least they seemed like they did, that the federal government simply does not have the power to regulate who gets let into what business, because they're making up a new power. This isn't just about regulating commerce. This is about regulating, this is about regulating culture. So, but because it was principally about business, in places of public accommodation, I believe is the phrase, they needed to, these business owners needed to be able to open their doors to anyone, and they couldn't put out signs that said things like "No Irish need apply" or "Whites only" or anything else like that. So that's where the kind of authority of the Civil Rights Act came from, is the Commerce Clause. The Supremacy Clause was something that was tested in a case called McCulloch versus Maryland, and it's from Article 1, Section 8 of the Constitution. And the Supremacy Clause is simply that whenever there's a conflict between the federal government and the states, the federal government wins. And McCulloch versus Maryland is a great illustration of that. It was so clear. McCulloch was the president of the Bank of the United States, or I'm sorry, he was the regional manager, basically, of the Bank of the United States. It's kind of an earlier incarnation of today's Federal Reserve Bank that regulates our currency. And the Bank of the United States had an office in Maryland, in the state of Maryland, of course, in one of the 13 original states. And in 1819, somewhere around there, a tax collector from the state of Maryland came in and said, okay, well, we've issued a tax on all banks in the state of Maryland, so fork it over. And so the branch manager, McCulloch, was dumbfounded. He said, well, you can't. We're the federal government. We have supreme power over you. And so he refused to pay the tax, and the lawsuit went to the Supreme Court. And John Marshall, who is kind of a frequent flyer in these kind of precedent-setting cases, writes very eloquently that, Maryland, of course, can't tax the U.S. government because the power to tax is the power to destroy. So if you can impose a tax, it means that you have the kind of ultimate legal authority over these entities. So today, that really means that if the federal government today wanted to abolish the states as entities, they could, because the U.S. has kind of the ultimate authority over the citizens and policies within its borders. It has the sovereignty, right? It has the power to destroy and the power to tax. Maryland couldn't do that, or Maryland and Texas and everything couldn't do that. But legally, I guess, it's almost a bad example because they could call a convention and the states themselves could kind of impose a new federal government. But either way, the federal government itself currently can do anything they want to the states, so long as, the people let them. So, all right, well, that's about all I want to talk about with federalism today with you. There's some other material that's covered on the quiz that I haven't covered in the lecture, in the module exam that isn't covered in the lecture, but it kind of all goes along with it. And so I've at least introduced you to most of these concepts. So I'm going to head right into California politics in my next video. So sit tight and watch the next one if you're kind of binge watching these videos. Hopefully you're at least reading the transcript if you're not watching them. And so tell your friends. But that's going to be it for this one. And the California one, I think, will be very short, and then we'll move on to the civil liberties one. Thanks for watching.